Thank you very much, Mr. Chairman. Thank you all for being here today. Mr. Rubin, before I give you the balance of my time to respond to Mr. McDonald, who just shared with us a communication between he and his lawyers that has now said that you're an outlier in your thought process, and to address the question that was just asked by my colleague. Of course, we know lawyers get paid. I mean, this is ridiculous. But let me just make a couple of comments, and then I'm going to turn over my time to you, sir. First, we have heard ad nauseum about the decision in Browning-Ferris. As my colleague said, we've had 35 hearings about this. It is interesting that every time my colleagues across the aisle don't like a law, they call it uncertain, ambiguous, unsustainable. Just because you don't like it doesn't mean you don't understand it, and they clearly understand it. And I just want to remind our Chairwoman Fox that intent is a standard that has been accepted in American jurisprudence for generations. It did not start here. And lastly, I just have to say this. I am trying to figure out, for the life of me, what Tim Scott has to do with what we are talking about today. So he worked at Chick-fil-A. So what? I mean, did he bring it up because he's black? Did he bring it up because he thinks Tim Scott might support his position? I take great offense to using a U.S. Senator who happens to be my friend in something so ridiculous. My time is now yours, Mr. Rubin.
Thank you. In response to the questions about uncertainty, first, a bit of background. I try to be well-versed in the law. Before I started practicing, I was a clerk for a Supreme Court justice. I try to be well-versed in the facts because my job as a litigator is to discover and know the facts and apply the facts. And I try to understand cases like the Browning-Ferris decision and the Freshy Advice Memorandum by actually looking to see what's written in those opinions, what standards are applied. You start with the Browning-Ferris decision. It actually simply reiterates the standard that I quoted before about sharing the essential terms and control over the terms and conditions. The standard itself is not objectionable. What people seem to be complaining about, Mr. McDonald and others, Ms. Kennedy, is that they have been advised that there's some uncertainty. But in each of the instances they've described to me, there's no way a litigator would pursue their case on a joint employer basis, which is why of the 9,000 FLSA cases, only a handful were ever pursued on a joint employer basis. What were the facts in BFI? We have to focus on them. BFI owned the plant. It set the shifts. It told the employees where to work. It capped their wages. It decided when they would have to work overtime. It decided how many workers would be working overtime. It decided when to stop the assembly line for breaks. It controlled the line speed. It had the right to veto any wage hike or wage change that Lead Point offered. It trained the workers. It had the power to fire, and in fact it did terminate 2 workers that it didn't want, and it had the power to fire the entire workforce. Those are the facts of Browning-Ferris. And any lawyer looking objectively at those facts under the standard that has been part of the National Labor Relations Act would conclude that that party should participate in collective bargaining, Browning-Ferris that is, because it had the right to affect terms and conditions of employment. And certainly, we haven't talked a whole lot about the Fair Labor Standards Act, but the Fair Labor Standards Act—
Mr. Rubin, if I could just interrupt you one moment. I really would like to yield the last of my time to our ranking member, if you would allow me to do that, sir.